morning. I'm not sure just what you want me to cover, but I would like to say that in 1965, Connecticut voted in the November elections to adopt a section to the Constitution which dealt with the education of our children. The language of that resolution, which started with a resolution I put into the legislature, simply said that our students were entitled to free public education. The language is simple, clear, concise, and I don't know what the problem is with it, but apparently we've had court cases ever since. In fact, no sooner was the amendment added to our Constitution than a case was already in progress, which was the Horton case, which ultimately the Supreme Court heard, and in 1977, I believe, held that the state now was governed by Section 1 of Article 8 of the Constitution, which made it a substantive and fundamental part of our law. And the word fundamental appears in the decision of the court in 1977. Well, the first case, which I've just mentioned, established that the school should be subject to the meaning and purpose of the Constitution, which was that there be decent education for our children. I use the word decent because everybody has a different word for what we're talking about. What we're talking about is that our students, when they graduate high school, should be prepared to make a living or make a contribution to our communities. Now, when I addressed the convention on this subject, and I believe I was the only one who really addressed the convention and spoke at any length, I used the word good education. And the reason I did was because in 1636, when the city of Hartford was established, when Thomas Hooker led his congregation down Cambridge into Hartford, and a few years later when New Haven was established, the first thing they did was to see that there was a school for kids. In fact, a year after Hartford was founded, they already had somebody teaching school. And they used the word good, spelled G-O-O-D-E, ancient British language. And I wasn't thinking of anything else except good education. So the first case that we mentioned, the attorney's name, George Horton case, established that Connecticut would hereafter be governed by the under the authority of section in the Constitution. And that case was no sooner over when the second case came along. It's a perennial. It's still before the courts and a matter of interest to this state. And that case went even further. That case said not only was there a requirement that students get a good education, but there was an affirmative function, duty of the court to step in and see to it. And the Chief Justice at the time said in 1998, this case has lasted too long and the kids have waited too long and it has to stop. And yet the Schiff case is before the court and appears in an editorial in today's Hartford Courant, for example. So I wasn't thinking of anything other than a good education, and like the rest of us, I'm willing to settle for an adequate or whatever that may be. And if I have a minute or two, I'd like to tell you of an incident that happened at the convention. A Professor Waugh, W-A-U-G-H, of UConn, was interested in promoting the welfare of the University of Connecticut, and he had submitted some a bill to get some recognition in the Constitution of the University of Connecticut. Well, he didn't like the language that was proposed to him, and he made some changes apparently in committee. And then when the final language came out, he addressed the convention, since it was his bill. He said he felt peculiar about accepting the language, but he knew that he either had to accept that language or the bill would not be passed. And he said he felt very much like the father-in-law the man whose mother-in-law, get this right, he felt very much like the mother like the man whose mother-in-law drove his new Cadillac over a cliff. He didn't know which to be sorry for. So he accepted the language with that little bit of humor. Now, about today's hearing, I am not a lawyer in the case, but I followed this subject for 40 years, excuse me, and I don't think a court is going to leave the children in the lurch. I'm very confident that the courts will heed the remarks of the Chief Justice in the second case, and will do the proper thing, which would be to send this back to the courts for a trial on the real merits of the case. I'm hoping that will happen. Thank you.